Hello and welcome to another edition of Immigration Nation. My name is Nicole Whitaker. I am an immigration lawyer. My office is based in Towson, Maryland, but I represent clients all over the country. If you have an immigration question and you need help with your immigration case, give us a call at 410 207 9272 to schedule your consultation directly with me. We do consultations in person, by telephone, or by video call, where you'll have your call just like this. Um, Today, I am answering a question from one of my followers. The question is, I just got married. I assume you just got married to a U.S. citizen or green card holder. What's the process to get my green card? How do I start the paperwork to apply for my residence? So the first question is, or the first step would be to schedule a consultation with an immigration lawyer. So without more information, I can't tell you exactly how to proceed. But let me tell you the questions I would ask you. So first, I would want to know about your immigration history. Are you inside the U.S. right now? Did you enter the U.S. legally with a visa or with a border crossing card? Or did you enter illegally without inspection? Are you currently in the U.S. or are you outside of the U.S.? If you're outside of the U.S., have you ever been denied a visa or had any issues getting a green card or visa in the past? Answering yes or no to these questions doesn't necessarily disqualify you from getting a green card, but these are the questions I would ask to be able to answer your question and tell you exactly how to apply for legal status. So typically, if you are outside the U.S. and married to a U.S. citizen or permanent resident, you would be applying through a process called consular processing. There are 3 steps to the process. First, we file the I-130 with USCIS. Then the case goes to the National Visa Center, and then you're scheduled for an interview at your local embassy before you come to the U.S., enter the U.S., and get your green card. If you are inside the U.S., you'd be applying for or determining whether you're eligible to apply for a process called adjustment of status. You can apply for adjustment of status if you are the immediate relative of a U.S. citizen, the spouse, child under 21, or parent of a U.S. citizen. Those are the only relationships that qualify as an immediate relative of a U.S. citizen. So important to note, if you are married to a permanent resident and you're here in the U.S., if you are out of status, you're no longer on a valid visa, you cannot apply for adjustment of status from inside the U.S. Depending on how long you've overstayed your visa, if that's the case, we might have different strategies for you. But one strategy is just to wait until your spouse can apply for U.S. citizenship. And then once your spouse is a U.S. citizen, then you're eligible for adjustment of status if you entered the U.S. with inspection. So if you are eligible for adjustment of status because you are the immediate relative of a U.S. citizen and you entered the U.S. with inspection, meaning with a visa or border crossing card, or you were waved through at a port of entry when you were walking or driving through, the process is you file a number of forms with the Immigration Service. You file the I-130, the I-45, an application for a work permit, an advanced parole. In addition, you have to file an affidavit of support by your spouse. You have to make sure that your spouse is eligible to file the affidavit of support. If they don't earn enough income, you can also use a joint sponsor. Once you file all of that paperwork, eventually you'll be scheduled for an interview before USCIS, where they determine whether your relationship is genuine and they confirm your eligibility for the green card. At the end of that process, you'll be issued a green card, either the 2-year green card or the 10-year green card, depending on how long you've been married to your spouse at the time the green card is issued. If you have been married to your spouse less than 2 years when the green card is issued, you'll get the 2-year conditional resident green card instead of the 10-year permanent green card. And at the end of that process, at the end of the 2 years that you have your green card, you have to file another form to get your 10-year permanent green card. So the answer to this question is it's complicated. It depends on your immigration status and where you live and the status of your spouse. Is your spouse a U.S. citizen or green card holder? So again, the first step is schedule a consultation with a lawyer to make sure you're eligible. If you file a petition with immigration that you're not eligible for, and you yourself are out of status, you're here on an expired visa, or you entered the U.S. illegally, then you might be putting yourself at risk of being placed in deportation proceedings. So the first step, no matter what, is consult with a lawyer, make sure that you're eligible for consular processing or adjustment of status before filing anything. If you would like to consult with me about your options to learn what the process looks like for your specific case, give us a call at 410-207-9272. Thanks, guys. Have a good day, and I'll see you next time on Immigration